Frank Newbould from Borden and Elliott, Peter Howard from Stikeman Elliott, and I are going to talk about the trial end of the thing. And Frank was going to start off, so without much more introduction, let me turn it over to him.
Thanks, Peter. I've put together a paper, and I'm going to be referring to some of it, and some of it I won't refer to it. The trial itself in the commercial court is something that doesn't take place too often. So many things get settled either by virtue of an injunction application, a preliminary hearing, a settlement, something being worked out. But trials do take place, and when they do take place, oddly enough, they sometimes look like a regular trial, but in fact they operate somewhat differently. The only rule in the practice direction dealing with trials itself, the trial proper, is that the court encourages the use of sworn witness statements. And I'll deal with that later, but as to whether that's a good or a bad thing and how it works, but that really is all that's there. And therefore, one may ask, why is it any different if that's all that's there? Why is the trial any different in the commercial court? In fact, what Peter Griffin was going to do was call this the new trial practice in the commercial court, and then his conservative nature got him to back off that. But why is it different? The first thing you will notice, I believe, is that the court itself is very experienced in these matters. When you go there with an oppression remedy, don't expect to have to read through Section 247 of the OBCA. Don't expect, if you're going for a receiver, to have to go through all the case law about what a receiver is and why a court can appoint a receiver and what the grounds for appointing a receiver are. The court will know that. The court will be more interested in the facts, the factual dispute before the court. That will be very helpful to you because you won't have to worry about, will the judge know what we're talking about? Will we have to spend a lot of time educating the court on this problem? Over at 361 University Avenue, as you can expect, there's a broader range, a broader experience of the judges, and oftentimes you have to take more time to educate the court. In the commercial court, you'll find you don't have to do that. Second thing is you'll find is that the issues are likely going to be narrow before you get there. Case management should achieve that. Case management should achieve a lot. It should achieve a lot of the stopping the game playing before you ever get to the trial, but it should narrow the issues. The judges will be very interested in trying to get the parties to understand what is and what isn't in dispute. Now, I referred to the Ashmore and Corporation of Lloyd's case in my paper, and I can assure you that this isn't just the favorite child of Justice Farley, although it clearly is the favorite child of Justice Farley. I was about a year ago asked by Justice Farley to speak one day we put on some kind of performance in front of all the trial judges in Ontario dealing with the commercial court. And lest any judge in Ontario hadn't yet read Ashmore and the Corporation of Lloyd's, there was a copy sitting on every desk in the room, well marked. And while the House of Lords is not a binding court, you'll find that it's a very persuasive judgment to all the judges on the list. And I wanted just to refer what that case was about. Was a case in which a number of underwriters were suing Lloyd's, and it was not a 3-day case or a 5-day case. And what the trial judge did at the outset was to order an issue as to duty owed to the plaintiff to be dealt with before any evidence was called, and that was opposed, and it went to the House of Lords. And the House of Lords upheld the trial judge in saying the court had the right to say we'll deal with that duty issue, because if it turns out that there's no duty owed to the plaintiff or the plaintiffs, that will be the end of the case, and otherwise it may narrow the evidence because of what the duty is. That case, what gave rise to that case, the facts themselves were probably unusual for our court, probably unusual for any court in terms of volume. The reasons of Lord Templeman indicate that at the outset of the trial, there were 60 binders of documents. After the trial started, it adjourned for a week so the judge could read some of the documents. It looks like they weren't using compendiums over there. When they returned, the plaintiff's counsel then asked to amend the points of claim or the statement of claim, even though it had been amended several times before. The judge allowed him to amend at so late a stage, and then at that point Lloyd's said, we want to determine whether or not there's any duty owing to the plaintiffs. And naturally enough, I'm sure the trial judge was relieved to think that they wouldn't have to perhaps go through all that evidence if it wasn't necessary. And what the court said makes it quite clear who's in control in the end on the process. And there's a very interesting dichotomy between the Court of Appeal and the House of Lords. And Lord Templeman referred to the remarks of Lord Justice Ralph Gibson in the Court of Appeal, and when he was being critical of the trial judge, said he claimed in particular it was wrong thus to take the conduct of the proceedings out of the hands of the plaintiffs, and thereby to disappoint the plaintiffs in their legitimate expectation that the trial would proceed to a conclusion upon the evidence to be adduced. And that was the Court of Appeal's view. Lord Templeman said, I disagree. The control of the proceedings rests with the judge and not with the plaintiffs. An expectation that the trial would proceed to a conclusion upon the evidence to be adduced is not a legitimate expectation. The only legitimate expectation of any plaintiff is to receive justice. That's a bit like beauty, it's in the eyes of the beholder. Justice can only be achieved by assisting the judge and accepting his rulings. One understands why the courts like the judgment. It certainly sets up a healthy tension between counsel ready to loaded for bear to proceed with a case and the duty of the court, according to this decision, to control, and the plaintiff can't necessarily expect to have the evidence led. Now that was an unusual case, calling for comments like that, and it's fairly clear that the House of Lords was awaiting the opportunity because of what had taken place in other cases. It's not all bad. I don't think you can expect that the trial judges in the commercial court are going to go around making crazy rulings and forcing counsel to do crazy things. By and large, the judges in the commercial court aren't crazy people. I do think, however, that counsel, you have to be prepared to act as counsel. You can't cower. If you have a duty to your client. Lord Roskill said it's the duty of the advisors of the parties, he's speaking of counsel, to assist the trial judge. Undoubtedly that's true. Undoubtedly that's good advocacy. If you want to persuade the judge to your client's cause, obviously you want to assist the judge in coming to that conclusion. But you also have a duty to your client, and you know the case, you know the evidence, and so you shouldn't, if the judge proposes something, don't cower, and because he's suggested it, go along with it if there's good reason not to go along with it. The judges on the commercial court can be persuaded, and they often are. However, that case, you better have it handy. Another thing about the commercial court is you'll find it's flexible. You can improvise to how a case will proceed. The court wants them to have things determined quickly and efficiently, and what Tom Heintzman sent to Justice Farley is undoubtedly a fair reflection of what commercial interests and corporations in this country think as well. They don't like the delay, they don't like the expense, they want to get things determined quickly, and you all know how clients get frustrated. And if you can do it faster, it's better for everybody, and I agree with Justice Farley, it's better for counsel as well. because if you're known as someone who can take a tough case, a tough situation, and get it resolved quickly, they should be the path to your door. I referred in my paper to one case in which I was involved 2 years ago. It was an oppression case, and from the time I was retained until the time the trial finished was about 6 weeks. And in that case, we obtained an injunction within a few days to hold the status quo in an oppression application, and 4 weeks later the trial started. And what happened was each side filed their affidavits, as you would on any application. We had cross-examination on most but not all of the affidavits. We then agreed that at the trial, the parties, each counsel could use the affidavits of themselves, the other parties, if they wanted to, could use the transcripts of the cross-examinations, and could call witnesses. And that's what happened. So it was a hybrid where we relied upon affidavits, documents, transcripts, and that each of us called their own client, basically to have the trial judge look the client in the eye and see who he liked and who he didn't like, plus a few other witnesses to fill in, witnesses who weren't involved with the parties. And it was over. That trial lasted about a week and a half. It took the cooperation of counsel. There were no motions required. A couple of 9:30 appointments resolved it. In that case, the trial judge was the judge who heard the injunction, so he was involved from beginning to end, and it was done quickly. I don't know what would happen if counsel would not agree on that procedure. I'm not sure the rules would allow the court to force it upon parties. I suspect that if it made sense, there would be certainly some moral suasion perhaps involved, but whether or not it can be done without the consent of the counsel, I guess, is an open issue. When you get to the trial, like any trial, you should make a clear and concise opening, obviously. And in the commercial court, you'll find, as Peter Howard will describe to you in some detail, how the documents should be prepared for the trial. And in your opening, it will be important not so much to tell a judge about the law, but to explain the facts and explain the factual disputes. As in any case, any plaintiff's counsel should make a clear and concise opening. You should take the time. You'll probably end up marking documents as an exhibit by consent, as more and more is the case at 361 University Avenue as well. You should, if you're defense counsel, not hesitate to ask to open before the plaintiff's counsel starts going through the evidence. I think you'll find the court will be willing to listen because the court wants to know what it really is in dispute at the outset. And if you think it's helpful to make a short opening as defense counsel, ask for it, and you likely will receive it. Diagrams of complex structures are clearly helpful, and in most matters before the commercial court, they're used. Pictures of corporations and arrows, transactions with arrows, that sort of thing. They're very helpful, particularly if they're agreed upon between counsel, as they usually are. It can save an awful lot of time. You can go through the documents. You can go through the transcripts. I remember one case I had before the commercial court, the trial. I was going through the transcripts and taking time as I went through to emphasize why this particular piece of evidence was important. And at one point, one of the many other counsel on their side popped up and said, "This isn't fair. You're not supposed to be able to talk about the evidence as it's going in. Just read the transcript and don't comment, and leave your editorial comments to the side." I wouldn't accept that kind of a comment. As I got going, next time I came to something and wanted to make a comment, I simply said, now if I were permitted to make a comment, I would tell the judge to mark this as being very important. And that was the end of that problem. But if you want to read the transcripts as part of your case, do it, and don't be cowed into not commenting upon it. It helps the court. Mr. Justice Farley spoke this morning about agreeing when the sun rises. That's important. When the sun rises, in commercial cases, is often the court will know when we're looking at the sun. The court will usually know when in the commercial world something should have happened. And if something normally in the commercial world would have happened, and that did happen, you're better off agreeing to it than fencing and trying to force the other counsel to prove something that may be of some difficulty in proving. If it's important to your case and it can't be proven, don't back down. But if it's a point that in all likelihood will be in the end proven, but they have some difficulty, and it's something that ordinarily would happen, you're going to make more points with the court in agreeing to it and getting on to what is more important and what is truly in dispute. Justice Farley spoke about a list of witnesses, and in that commercial list memorandum, it asked counsel to estimate the time of witnesses, names of witnesses, how long you're going to be in examination, cross-examination. In my experience, that sometimes can be done, often it can't be done. Cross-examination, as you know, is something you can't program in advance. You don't know how you're going to do. You don't know what always is going to be said, nor do you know whether you're going to call witnesses. Oftentimes, as you know, in a trial, you wait, particularly if you're a defendant, to see how the evidence is going at a point just before you call a witness. And in those circumstances, you always cannot tell. Scheduling is very important. My plea to the court on this question of witnesses and programming witnesses and how long are they going to be, it's clearly important in trying to schedule the trials. Scheduling is the most difficult job, I think, or one of the most difficult jobs that courts face. And that's very important. You should do your best to try and do that. My plea is that lawyers and parties are humans, and even the most experienced counsel have difficulty estimating times, estimating how long the case is going to last. It's not always just a question of lack of courtesy, communication, or common sense. It's because a trial is a trial that sometimes you can't determine all these things. And so I would hope that the court and the judges will understand that, and I believe they do understand that we're all humans, and it's not always just a question of lack of courtesy, but it's often the very process itself that leads to these things not being always able to encase themselves in advance. You must obviously try to do your best on that. Now then, one of the most contentious issues, I think probably what counsel asked most about the commercial court, is the statement in the practice direction that the court encourages the use of sworn witness statements to replace examination in chief. That's something to people who don't practice in the federal court very much, and I'm certainly one of those. That's something that before this came was a foreign notion. It's something that people aren't sure about. It's certainly not limited to expert witnesses, nor is it intended to be limited to expert witnesses. It's intended to apply to all kinds of witnesses, and it's designed to shorten the trial, which in itself is not a bad thing. It is experimental. I do believe that the court recognizes it's experimental. I believe the court encourages it. I don't think it's going to be forced on counsel if they're reluctant. There may be moral suasion in cases there may not be. Partly it'll depend upon the particular judges. One judge may have a different view than another. There are at least two schools of thought. One is that if it's a credibility issue with a witness, a lot of counsel will say, I want to see that witness give evidence in chief before I cross-examine. How that witness gives his or her evidence in chief will be very important in determining how to cross-examine that witness. And it can be far different coming from a document prepared by a lawyer, as affidavits are in motions but not at trials. It can be far different for that witness in chief, orally in the box, than it can be in a document prepared by the lawyer and signed by the witness. And if it's a question involving credibility and you're the counsel on the other side, you may want to insist on that witness giving evidence in chief orally rather than by written statement. On the other hand, another school of thought is that it's easier to cross-examine a witness if they haven't had time to warm up. In the Air Wars case between Canadian Airlines and Air Canada, which also was a case that came on in jig time and lasted far less. I've forgotten, but it was something like a 2-week trial in front of Justice Callahan instead of what, 4 weeks instead of a 4-week trial instead of what ordinarily would have been about a 3-month trial. The parties agreed to use witness statements, and they tried them. And one counsel afterwards told me it was not, while our firm was involved, it wasn't someone from our firm. Another counsel, very experienced counsel, said to me how much easier it was to cross-examine a couple of particular witnesses because they had not had any time in chief to warm up and to get the feel of giving evidence, and he thought it was like picking apples out of a barrel. And that these were witnesses who were experienced businessmen, who were sophisticated, not people who were afraid to talk, yet he felt he had a real edge because he got them cold. And he said it had, in his view, it had a real effect on what he was doing. That was an experienced lawyer speaking, and when you think about it, it also makes sense. If you're going to use them, one way around that may be to have the witness in chief sign a witness statement, put it in, but warm them up for 15 or 20 minutes and talk about the normal things you do with the witness in chief for the first few minutes, get them warmed up, get them talking about some of the issues. He'll have a chance, he or she will have a chance to become comfortable, and then let them go to be cross-examined. I should think that would be a much safer way of doing it. Whether those witness statements will be used in the future, time will only tell. I myself haven't been involved in a case where witness statements were used at a commercialist trial, and I've had several commercialist trials, but in the one case I referred to in the oppression remedy case, it was like that because we had affidavits that were used and we had cross-examinations. It seemed to work in that case. Time will tell. Again, if it's going to be helpful to your case, suggest it. If you have good reason to think it won't help you, don't be coward. Explain, if you're asked to agree to it and you have reason not to, explain your reasons and stick to your reasons. But it's an experimental thing, and only experience is going to tell each of you whether or not you think it's a good idea. Rule 53.02 is referred to in the practice direction, and it provides that that the court may make an order before or at the trial allowing evidence of a witness of a particular fact or document to be given by an affidavit. It provides, however, that that's only if the adverse party reasonably doesn't require that person for cross-examination. So if you think the person should be cross-examined under that rule, the court can't make an order. I question whether it's needed, that rule, actually, because if it's something that you don't think you need to cross-examine on, surely you can agree upon the fact without being forced to have an affidavit, but maybe one way of doing it. Expert witnesses. In most cases in the commercial list, I shouldn't say that, but a lot of cases, they're expert witnesses. The rule provides for 10 days notice before the trial of the reports. Don't try it. You'll find with case management you're going to be told, encouraged, forced to exchange your reports before that so that each side knows what is going on. It's not trial by ambush, and so you can have proper time to prepare, and so you're not wasting time at the trial seeking adjournments because you've got to do some more experiments or whatever because of what the expert said. So you have to get your reports ready in timely fashion and exchanged in a timely manner. Some of you will have experienced in trials the practice, and it used to be that experts weren't, you called the expert witness, you qualified the expert, and then the expert talked, and you didn't file reports. Some judges wouldn't let you file reports unless the cross-examining counsel wanted to use it to cross-examine. That's giving ways, as you will know, and now more often you file the reports. I would be surprised in the commercial court if the report wasn't simply filed and you led your expert through it in chief to highlight it before cross-examination. Lastly, in closing arguments, like any other trial, the one thing you may find is you'll be asked to file written argument. with the court, depending upon the nature of the case and the length it's been. There's good and there's bad in that. The bad is that it will probably add to the cost and take longer. And also, you will not be able to, you won't be able to field questions from the judge as well. You may lack the ability to find out what's bothering the judge about your case, and you sure want to know that before it's over. The good is that you can take time to make it concise, planned well, think it through, sometimes more easily than at the end of the evidence, and you're getting kind of worn down, so that there's good and there's bad. You may find being asked to do it more than you would elsewhere. The only thing about the case briefs I'd say is, for goodness sakes, do pare them down. Use the pages that you want to make use of, not anything else. Don't, however, be unfair in what you do. Do not take a page and the next page kind of takes away a bit from what you're saying. Don't leave it out. You'll find likely other counsel taking you up on it. And the next page will then ring much larger in the ears of the judge than if you'd put it in there in the first place and dealt with it that way. I think those are really the differences. You'll find that in a court, once you get experienced in it or used to it, you'll find it's an enjoyable place to conduct a trial. It's run by judges with experience and knowledge, which should help you a great deal. Thank you.
By reason of his advanced age and seniority, Mr. Newbould got to choose the topics, and he's already taken up most of the practice before the commercial court. My assigned topic on its own is so boring that I've chosen to take it as an example of what I see as the bigger or biggest issue facing the commercial court and the users of it, and that is, how far can the court, or how far should the court go in insisting on its own ideas as how the case should be presented, and what should your reaction be as counsel? And as you can see from everyone's paper, we've all been instructed at least well enough so that we all have included Ashmore in the Corporation of Lloyds. And that, to me anyway, is an example of legislating common sense. And that is where the tension is because most of these rules legislate common sense. The genesis of the commercial court, as I understand it or believe it to be, was mostly to address two things. One is that there be a specialized tribunal to deal with specialized cases, and I think Frank has dealt with that very well, and indeed on most CCAA or receivership matters, you won't need to spend any time drawing an elaborate picture of the obvious. But the second part is, it seems to me that the commercial court practice directions for trial were addressed at the assumption in the rules of civil procedure that both sides want to proceed expeditiously and efficiently in good faith to resolve the dispute, and the experience that that wasn't the case. In normal trials or in normal procedure, you can use the rules of civil procedure, and they are used to, Trish called it trench warfare, I've called it wars of attrition, and you can use the discovery process and the scope of discovery based on a semblance of relevancy and any other matters, and many other matters in the rules, to expand the time that it takes to get to trial into infinity almost. And that's been done. And it seems to me that the commercial court was a reaction to that. And the flexibility that the judges are given is aimed at preventing people from doing that. And there is, and there ought to be, little patience for the inefficiencies and delays that counsel have used in the past to make matters stretch into infinity. And I think it's understanding this duality is important as you approach a commercial court matter and a trial. And I'm going to get to compendiums and documents at some point. But because that's the way the judges are going to treat you. They're going to say this is a different system and that you have to explain why you've departed from the practice directions which are aimed at these abuses. It is possible to insist on the normal civil procedure and trial procedure, and depending on who you've got, the reaction may or may not be volcanic. It is important to be aware that the expectation is that this is a different process. And the way I like to think of it is that the court is entitled to a reason, not an excuse. If you've thought out of a reason and then can present a reason to the court as to why you've departed from the practice direction, number one, showing awareness of it, and number two, showing that you've thought about it, you are entitled to a judicial acceptance of that. If you offer an excuse, you are letting down what I see as counsel's side of the commercial court bargain. In order to use the list, you are, in effect, saying that you won't offer an excuse. At present, and this is what I see as the main issue, the reaction tends to be a bit uniform. And if there's anything that's going to discourage users of the commercial court, it is a judicial reaction that is uniform to both types of departure. And if there's a watchword for counsel, as I think Frank said, it is offer a reason and a rationale for your departure and stick to it. Now, turning to what I'm supposed to be dealing with, that is compendiums and proof of documents. And they're dealt with in the practice direction at present in numbers 50 through 53. In the new one, they'll be in 45 through 48, and I'll deal with them and the changes that they're going to have made. Number 50 says that you've got to file your material at least within the time prescribed by the rules. The change that's going to be made is that it's going to be stated that you have to do it before 2 p.m. on the day before. As a matter of common sense and experience, that's not going to happen. Especially in CCAA matters, it doesn't happen. Issues arise, and they just arise in the night before. I think in that case, that's an example of having to have a reason, and it also is using the commercial court staff and treating them fairly, because they are, certainly in my experience, the best and most accommodating staff that exist in Ontario, if not in other jurisdictions. And they are susceptible to abuse because of that, because they're so good, friendly, and cooperative. And I guess the number one rule is if you're going to abuse or seek to abuse Belinda and Olga and that cooperation, then again you are letting the side of counsel down, because that is a rarity, and it's a rarity to be treasured. The next commercial court practice direction as to documents is 51. It's number 46 in the new practice direction, and that says that you have to advise the list of the documents that you require, and it is suggested that counsel coordinate on a common marking scheme. What's new in the new practice direction is that there is a requirement that a representative attend at the commercial court list office the day before a hearing to ensure that the court materials are available. You should be aware that the excuse that they were filed will not be accepted as an excuse any longer. That's an excuse as opposed to a reason. Someone from your office has to go up and make sure that the materials are in the file. That's sensible, and it seems to me a reasonable approach. And I can't think of a reason that you could offer for departing from that. The next rule deals with compendiums. And it's the same in the present rule, by and large, as the proposed practice direction number 47, with the exception that there is an express reference in the new one to the Saskatchewan egg producers case, which is only slightly less quoted than Ashmore and the Corporation of Lloyd's. And again, it would be helpful to have, and all of you now do have, the Saskatchewan egg producers case, where Justice Farley has gone to some considerable length to address what he sees as important in compendiums. What is a compendium? Justice Farley, again in the Saskatchewan egg producers case and on other proceedings, has said that he's a yellow tag special. Well, it seems, again, to me that compendiums are tools or techniques for persuasion. And if it makes sense in your case, you will use it. If it doesn't, don't. But again, offer a reason or a rationale why you're not going to use it. In practice, the compendiums of the standard that Justice Farley has described are rare, in my experience. And the standard that he set out is honored more in the breach than in the observance. And that's been so because of time, because of the complexity of matters, the work habits of counsel, and the different ideas that people have of their case. What is not an acceptable reason is, and people have talked about the 3 C's, is that you haven't tried, or that counsel have, one side or one party to the dispute haven't been prepared to address the issue on a cooperative basis. If that's the reason, I think you're entitled to go before a 930 judge and say that, and have the court deal with it. But you better be right when you do that, because in effect you're throwing eggs at the other counsel. And that, it seems to me, is the proper policing mechanism for a 930 judge. It's not something you can do at trial. The other practice direction on documents is number 53, and it deals with diagrams, corporate organization charts, list of persons, and point form chronologies and other synopses of complex or technical evidence. Again, that's a technique of persuasion. And those type of things have always been used and have always been possible with reasonable and cooperative counsel on the other side. I don't think we can suggest, and they were being used before the commercial court existed, and they will continue to be used and possible with competent and reasonable counsel on the other side, and will continue to be impossible with the other sort. And I guess the only thing that you can ensure is that you are not one of the other sort. And insofar as the commercial court attempts to legislate the other sort out of existence, as I've summarized here, that's King Canute bidding the waves to cease. There will always be those type of people and those type of counsel, and your only recourse, as I've suggested, is to ask the commercial court to draw the right conclusion and discipline that approach. If there's one thing that I'd address to the judges on the commercial court, it is that you should be discerning in your reaction. At present, as I've said, it's my experience certainly that the reaction is uniform. It is a lecture, a uniform lecture, and maybe that's necessary to get the message across at the outset. But counsel who are trying or attempting to use the rules or practice before the commercial court ought not to be met with the same reaction as those who aren't being cooperative and competitive. Sorry, cooperative and using common sense. They are being competitive. That snuck in. So that's mine.
As I listen to the comments that have been directed on the trial practice side of things, it's interesting, looking at Justice Zuber's report some years ago, which led to our last set of reforms, Justice Zuber said that the history of the Ontario courts, with the exception of only a few periods, has been marked by constant change and adaptation. In my memory, I think back to the early days of practice, and I think of the battle analogies that I've heard made by some people who have spoken earlier, or warfare analogies. It seemed that one was able to approach the day of a trial like a battle where you were unencumbered with too much detail. It would only be by inadvertence if you'd actually committed yourself to something in a pleading, and in that way you had a good deal of scope as far as how you proceeded through a trial. Hopefully the expert report was no longer than a page so that you hadn't let on too much of what it was all about. And the day dawned, you had a lovely open field in front of you, a couple of nice wooded gullies going up towards the enemy, the mist shrouded around the forest on the edges so that you could work up the sides, and the trial was going to be an absolute delight. The horror, I think, that one's sort of trial by ambush nature, and I'm sure none of us have gotten rid of it completely, has, in looking at the way in which we have become so much more process-oriented, is on the day of the trial, you feel like you've arrived, having already phoned ahead to say that you'd be there at the battlefield at a certain hour. You'd sent a telex that very morning as to the time of the attack. You were going to make sure that your opponent had all of the details as to the number and strength of your soldiers, the sort of armament you had, the fact that those tanks up on the left side over here were actually dummies and couldn't fire, and that the attack that was coming from the right was a ruse, and certainly don't be the least bit distracted by that. So one can understand well how there has been, perhaps amongst the true litigator, some real sense of reluctance and dismay as the nature of your battlefield changes, and the one point I'd forgotten is somebody had, of course, filled in the gullies and cut down the trees. So I think that all of us, when we read something like the trial requirements memo, face it with a certain element of dread that the certainty is coming, that not only has the rule of disclosure, which has been along since 1985, substantially changed the nature of trials, but essentially one is going to be involved in a process in which one has to address one's case as to the detail and the strategic decisions you make a good deal earlier. And I think that what is of real concern to me when I see that level of development is, firstly, that this isn't a trend which is out of step with what is happening in other parts of our courts. I think that it may find more immediate expression in this trial requirements memorandum, but I would suggest within a very few years, all trials in the Ontario Court General Division are going to operate on very much the same sort of basis. Secondly, that when we have to make these sorts of decisions in our cases, not the week before, not the weekend before, when you're finally prepping a witness, but when you're making the decisions a month, perhaps 2 months before, when you're mapping out the witnesses you're going to call, how that evidence is going to be presented, what documents are going to be important, that these aren't just process-oriented decisions that we're making. We're making decisions which are key to the manner in which the trial is going to proceed, and you have to recognize the fact that just doing the minimum that's required by the various documentary exchanges and requirements isn't the answer. The answer is to think very carefully about what you're doing at the time. I'm sure all of us have been guilty from time to time over the years, you don't have to raise your hands on this one, of filing what might be called a pro forma pretrial memorandum. You know, the kind that says, theory of your case, I win, theory of the opponent's case, the opponent's memorandum, length of trial 3 days, chances of settlement ought to be good, or that ubiquitous question mark, all those sorts of things. And in this process that is looming immediately in front of us, every time we take one of these steps, we have to take it knowing that we're charting now the course and the conduct of the trial, and I think it means that we have to be very careful. And it's not something which is new. If one looks at the United Kingdom practice, and I've set some of the details out on my paper, they've been doing this sort of thing, albeit absent discovery, oral discovery. They've been doing this sort of thing for years. They've been at it since 1895. They have all of the sorts of attributes of our trial requirements memorandum. I understand that since 1895 that they have had essentially one users committee. It's a bit long on the tooth, and it's due for a change, unlike ours. But they have had a limitation on the calling of expert evidence, and in some cases an order that there be a meeting between the experts where necessary. And that's a little different than what's in our trial requirements memorandum, but an order that the experts meet is a very strong intervention. That the experts testify at the same point in the trial. So you get all the factual evidence out of the way, and you call the experts at one time so that that phase of the trial is all dealt with in the same pod, if you like. They call them bundles of documents. Compendium is a word that they don't use, that they have. They have a pretrial memorandum, a chronology, a list of dramatis personae, and they have a lovely practice, which is where judgment is reserved, that a draft of the judgment is circulated to counsel ahead of the date that it's pronounced. Now, I, reading on quite enthusiastically, thought that that meant you got to critique it and say things like no and revise and wrong result. But apparently, it's only so the counsel may be ready with any points arising when judgment is delivered. I suppose the alternative in our practice would be to send in a disc to the judge that has the correct disposition in it. Now, the other area where we see all of this kind of following a pace is the report of Mr. Justice Blair's Civil Justice Review Committee, because it's heading in the same direction. It's contemplating a court with sort of a multi-door approach, that is, ADR being very much a court-connected function as it is with our pilot project here. It does emphasize, as I think is correct, that there are going to be cases where you can't solve it by the various ADR doors with various degrees of intervention that may arise, and that there's got to be a strong ability to deal with trials and deal with the backlog. Case flow management, that a case has to, between 9 and 12 months, go from the date of filing to a settlement conference, remembering that the report differentiates between a settlement conference and a trial management conference, and in the further 9 to 12 months find its way to a trial. So that's a relatively short horizon, 24 months and perhaps less, to get a case from start to finish, which hasn't been the experience across the street. Very much makes the point that court-connected ADR is here to stay. Raises again the idea of cost sanctions. You know, we seem to have a very kind of moth and flame reaction to cost sanctions. 1985, the rules were amended to provide that costs may be awarded in effect against a solicitor who's responsible for delays or abuse of the process. We've had case law about it. We've sort of danced back and forth with it, and it's never really happened as being much of a factor in our practice. Justice Blair's committee says that it should be much more of a factor, both as to improper scheduling issues, that is, if you over or underestimate the length of a trial, more underestimate, and or if you are running the trial far too long. So again, we have the specter that counsel may pay. The simplified rules should be an element of our practice. And there was an interesting comment that said, in general, lawyers support a system of case management where judges take control of the timing of cases out of the hands of the lawyers. Now, I don't think that we necessarily have that system in the commercial court, but it gives an indication that counsel are beginning to perceive that process, that is, getting a case on a conveyor belt and getting it down through a series of identified steps towards a resolution, is more likely going to prompt a case to resolve than not. Now, the other element that is coming along hand in hand with that is the extension of the ADR pilot project, and we were going to address some comments in the panel discussion of that and what implications that has to the commercial court practice. 8 out of 10 of our cases here will find their way into the ADR project beginning in June, and that's going to have a profound effect, I would have thought, as to the flow the cases take. The simplified rules. The report of the Simplified Rules Committee deals with cases that are of a dispute less than $40,000. Well, I appreciate that there aren't that many cases in the commercial court that are at the $40,000 range, but it is described as being an optional procedure for cases over that amount. And there was a lot of support amongst counsel and judges writing into the Simplified Rules Committee as to the fact that that procedure should be more mandatory for larger cases. But it has an interesting twist in the summary judgment end of things. You have the option of going for a summary judgment motion or summary trial. And the summary judgment motion doesn't have some of the frailties that we've seen, perhaps less so in the commercial court, of judges not being as apt to grant summary judgment in the way that perhaps the rule was heralded at the outset. And the simplified procedure is that a judge on a motion for summary judgment, if they decide that there's a genuine issue for trial, they shall nevertheless grant judgment unless they think that the matter can't be resolved because of a credibility issue, or that it would be unjust to decide the issue on the motion. So essentially there's more of a push towards that. But the summary trial process is really quite interesting, because there, again, no discovery. The evidence of the parties is by affidavit. You can cross-examine for 50 minutes. So you get to the end of the 50 minutes, if you haven't asked the question, it's all over. So you try and get the question up a bit earlier. Re-examination, a full 10 minutes. Reply evidence only with leave. Oral argument for not longer than 45 minutes. Judgment at the conclusion of the summary trial. So that thrust, slightly differently dressed up, is consistent with the sort of thing that we're seeing in the commercial court. What's happening on our civil trial list? Well, I put in the material what has started off on the 1st of May as being the Team 1 approach, which is a trial management hearing in civil cases. It reminds you of the days when we were over in front of Justice R.E. Holland over in assignment court, trotting out the usual excuses that even with the benefit of cryogenics, grandmother had died yet again. But the practice there is that the week before, you essentially have to file a case management, trial management hearing form where you hit a number of the points that we've seen in the commercial court. List of outstanding issues. It's right at the very back of the material. List of outstanding issues, agreed statements of fact, chronology, joint document brief, expert reports exchanged, list of witnesses exchanged, factums on the issues of law, joint case brief. Well, it reads like what we're talking about on the commercial list side. That's on one of the lists in the civil non-jury jury side, but it's going to be in all of the lists before you take very long to blink again. So that essentially, coming to grips with this trial practice, we're going to be coming to grips with how we're going to try cases throughout the system. So it's here to stay, but I think, as others have said, we owe the duty to our clients to look at it critically and make sure that we give it the flexibility to properly operate. The English Guide to the Commercial Court Practice says this guide doesn't seek to provide a litigation handbook or a blueprint to which all litigation must unthinkingly conform. It rather thinks to provide the framework within which litigation in the commercial court can continue to be conducted in accordance with the objectives of the court. So having said that, my message is fairly simple. You have to be flexible. You have to look at each of your cases on the basis that meeting each of the requirements of the process may not be absolutely necessary or the right thing to do, but you have to look at it on an individual basis. And if you want to vary that practice, you have a 930 judge, you may have a case management judge. You can always get whatever slack you need by putting up the right argument as to why you don't have to conform with it in quite the same way. But don't be afraid to be flexible as to how you approach it. Our primary goal is to effectively resolve these cases. Our duty is to our client to make sure that it's done properly. So bearing that in mind, just a couple of points. You're not going to be limited by any shape of imagination in your advocacy, I wouldn't have thought. If you want to set up your documents and the aids to the court in a different way, it may change from case to case. It may include a chronology or a chronology in something else, or a handout or a book or a set of diagrams or charts. But just think carefully about how it is you're going to present it and make sure that it is at its most effective. Just meeting the requirement to the trial memorandum may not get the message across. I can think of a case that I was involved in where the issue was whether or not my client had affected the viability of a particular business. And in order to demonstrate what this business would have done, counsel on the other side set up a series of charts showing where it would have gone after the cataclysmic event for which my client was responsible. Well, these charts were on the wall of the courtroom, and as the trial progressed, periodically they would fall off. And it was delightful at certain stages of the evidence that these diagrams would they wouldn't just fall, they'd sort of collapse and hit the floor. And I took great delight in the timing of that, because in the end, I think it more graphically set out how this business was going to fail than anything I could have thought of by way of advocacy. The other element I think that is worth thinking about is your witness list. And this is purely a mechanical thing. I've always been very careful in a trial about not undertaking to call a witness unless absolutely necessary, because I think you can get yourself in a whole lot of trouble if you undertake to call a witness when, as the trial progresses, you realize you don't need that witness. And why would you want to call them? Now, when you're preparing a witness list, you better be absolutely clear with your opponent as to which witnesses, if any, you're undertaking to call, and get the same understanding with them. Because if by just delivering a witness list and leaving it unsaid, especially if you're a plaintiff, you may find you get to the end of your case and somebody says, well, what about Peter Howard, who I've been looking forward to cross-examine for years? And the answer is, well, I'm not calling them. Well, you've undertaken to call them because of the list you've delivered. So I think you'd be very careful about how you deal with that as far as the witnesses. If you're going to use so-called canned evidence, there are degrees, and others have talked about it, and I'm not going to deal with it any more than to say this. Be awfully careful that the canned evidence is in the witness's own words, or as close as you can get them. Because there are a lot of people who don't talk the same language as we do. We depart the human race when we go to law school. We develop a language all on our own. And we're used to it, and judges are used to it when we do affidavits, and we all have our affidavit styles, but ordinary folks don't talk that way. And you can get a witness in a lot of trouble, especially one who's less sophisticated than your average business person, by putting it in your words instead of theirs. And there may be some real advantage, and when you sit down to do all of this, to have the witness actually dictate it, or dictate a portion of it, so that you get some of this in their own words, and you can work with them on it. You take out the damaging part and the dangerous part and the part that you know is wrong, even though they said that's what happened. But you at least try and get it in the witness's own words so you don't cause difficulty from that point of view, because I'm sure all of us have seen a cross-examination where somebody says, well, let's look at paragraph 14 of your affidavit, Mr. Smith. You say such and such, and they look at it, and you can just see what's going to happen. What's that mean? I don't know, my lawyer wrote it type thing. So you've got to be careful, because in a trial that can be devastating. You can kind of duck that on the transcript of a cross-examination. So you've got to be alert to that. The other point is, you remember, you're backing up your preparation. You're always in this process backing it up. You're learning your case early. When you do this canned witness evidence, you've got to be sure you've got it all there. Because if that's going to be their chief, if your arrangement with the other side and your social contract with the court is that this is going to be the witness's evidence, you better be sure it's all there. Because if there's a vital point you haven't touched, where do you get it from? Re-examination? That's when the old Boston cream pie comes in. So you've got to think through very carefully, if you're going to go that route, that you've got all the vital elements to the evidence there. Because if you're short something, you've got a problem. As to the trial proper, the whole sense of a commercial court trial that I think we all take from the Trial Requirements Memorandum and the fixed trials and the commitments to time is that you've got to deal with it in a compact way. But don't let yourself be rushed through the vital parts of the case. Don't feel that sense of having to speed ahead, because there's always a certain flexibility in timing that can be found. And remember, your ultimate duty is to present your client's case as well as you can possibly present it. And we all have been involved in circumstances where we've gone too fast and omitted to deal with something. And you've got to be very careful that you cut all of those points, or you don't cut those points too short. So when you're finally there, it shouldn't be any different than any other trial. You have certain aids, you have certain shortcuts. You can expect that your trial judge is better educated as to your case. But when you're there to do one thing, and that's to present your client's case as well as you can. And it's a trial like any other trial. And there you've got to take the time and take the care. So what is the general effect of the trial requirements memorandum, and what I chickened out in calling the new trial process in the commercial court? I think you're going to find a better educated bench as to your case. You're going to be better prepared because you've had to make the decisions a lot earlier. You're going to know your case a lot better. You're going to settle a lot more cases in the course of that process. I just don't think there's any alternative to that. But lastly, when you get to trial, it's still a trial. And you should run it like a trial, and remember that that's where cases are won or lost. So you can't let the process dictate your own initiative, imagination, and advocacy. So I hope that in our panel discussion, which is to follow, we can touch on some of those points and just explore them a little bit further. Our panel is going to be Lyndon Barnes, Justice MacPherson, Justice Farley. Either of these two who can hang around are welcome to. And I would repeat, you know, if you've got any questions or thoughts or anything to add in the course of this panel discussion, I'd welcome it, because this is a terrific opportunity to try a few things on for size without getting burned in the course of a trial.